Have you ever had a brilliant idea, a spark of ingenuity that you knew could change the world? Throughout history, countless inventors have experienced that same thrill, that same burning desire to bring their creations to life. From Alexander Graham Bell's telephone to Thomas Edison's light bulb, from George Washington Carver's agricultural innovations to Stephanie Kwolek's life-saving Kevlar, history is replete with individuals who dared to dream and, through their inventions, reshaped our world. But the journey from idea to impact is rarely straightforward. It requires dedication, perseverance, and a crucial understanding of a powerful tool patent law. Patents are legal safeguards for inventors. They provide exclusive rights to your inventions, preventing others from making, using, or selling them without your permission. Imagine the groundbreaking Apple computer born from the minds of Steve Jobs and Steve Wozniak, or the ubiquitous Windows operating system, meticulously crafted by Bill Gates and Paul Allen. These innovations, protected by patents, revolutionized the tech industry and continue to shape our digital lives. But patents aren't limited to the realm of computers and software. Consider the groundbreaking work of Dr. Tu Youyou, whose discovery of artemisinin, a powerful anti-malarial drug, saved millions of lives. Her patent on the production process of artemisinin not only protected her invention, but also paved the way for widespread distribution of this life-saving treatment. Even everyday items like the ubiquitous blue jeans invented by Levi Strauss, or the revolutionary drinking straw patented by Marvin Stone, demonstrate the power of patents to transform simple ideas into enduring successes. The patent process, while complex, is a navigable path for those who dare to tread it. This guide is your roadmap, providing you with the knowledge and tools to confidently protect your own inventions. Whether you're an aspiring entrepreneur with a game-changing gadget or a dedicated researcher on the cusp of a scientific breakthrough, understanding the intricacies of patent law is essential to safeguarding your creativity and maximizing your impact on the world. The very foundation of United States patent law is enshrined in the Constitution. The Founding Fathers, recognizing the power of innovation to drive progress, wisely included Article 1, Section 8, Clause 8, granting Congress the power to promote the progress of science and useful arts, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This seemingly simple clause gave birth to a robust system designed to incentivize innovation. By granting inventors exclusive rights to their creations for a limited time, the United States patent system encourages the development and disclosure of new technologies. This exchange, granting exclusive rights in return for public disclosure, benefits both the inventor and society as a whole. Inventors gain a competitive edge in the opportunity to profit from their ingenuity, while the public gains access to new technologies that can improve lives, drive industries forward, and address global challenges. The United States Patent and Trademark Office, or USPTO, is the governmental body charged with administering patent law. It examines patent applications, grants patents, and provides resources and guidance to inventors navigating the complexities of the system. Understanding the USPTO's role and the legal framework it operates within is crucial for anyone seeking to secure patent protection for their inventions. One of the first questions budding inventors often ask is, what can I actually patent? The world of patentable subject matter is vast and surprisingly diverse. In general, any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, is eligible for patent protection. This broad definition encompasses a wide range of inventions, from groundbreaking medical devices and sophisticated software algorithms, to innovative consumer products and novel manufacturing processes. For example, a new type of prosthetic limb, a more efficient solar panel design, or a revolutionary method for three-dimensional printing human organs could all be eligible for patent protection. However, it's important to remember that not everything is patentable. Abstract ideas, laws of nature, and naturally occurring phenomena are not eligible for patent protection. Additionally, inventions must meet two key criteria: novelty and non-obviousness. Novelty means that the invention must be new and not previously known or used by others. Non-obviousness means that the invention must not be an obvious or predictable variation of what already exists. For example, imagine you've invented a new type of bicycle helmet with a built-in light. To be patentable, your helmet must be novel, meaning it incorporates a unique feature or design not found in existing helmets, and non-obvious, meaning the addition of the light is not a simple, predictable improvement that any ordinary person skilled in the art of helmet design would have readily conceived. Embarking on the patent process can feel like navigating uncharted territory, but with careful preparation and a clear understanding of the steps involved, you can significantly increase your chances of success. While seeking professional guidance from a registered patent attorney or agent is always recommended, there are several crucial steps you can take on your own to lay a solid foundation for your patent journey. First and foremost, meticulously document your invention. Maintain a detailed inventor's notebook, recording your ideas, experiments, successes, and failures. Use clear and concise language, date each entry, and have a witness sign and date each page. This meticulous record-keeping can prove invaluable if you ever need to prove the dates of conception and reduction to practice of your invention. Next, conduct thorough prior art research. Prior art refers to any existing information about your invention, such as previously published patents, scientific articles, or even publicly available product descriptions. Understanding the prior art landscape is crucial for determining the patentability of your invention and crafting a strong patent application. Finally, start thinking about the claims you want to make in your patent application. Claims define the legal boundaries of your invention and are essential for securing the broadest possible protection. Begin by identifying the key features and functionalities that make your invention unique, and consider how these features could be broadly or narrowly defined. A patent application is a formal legal document that describes your invention in detail and outlines the scope of protection you are seeking. It's essentially a blueprint for your invention, providing a comprehensive technical disclosure that enables others to understand and potentially recreate your creation. Now, a well-drafted patent application typically consists of several key sections. First, there's the title, a concise and informative title that accurately reflects the subject matter of your invention. Next, the abstract, a brief summary of the invention, highlighting its essential features and purpose. Then we have the background of the invention, which is a description of the technical field of the invention and any existing problems or limitations that your invention addresses. The summary of the invention follows, offering a concise overview of the invention, emphasizing its novel and non-obvious aspects. After that comes the detailed description of the invention, a thorough and detailed explanation of your invention, including its structure, function, and operation. This section often includes drawings or diagrams to illustrate the invention and its various components. The claims section is really the heart of the patent application, defining the legal boundaries of your invention and the scope of protection you are seeking. Claims are written in precise legal language and must be carefully crafted to be both broad enough to encompass potential variations of your invention and narrow enough to be patentable over the prior art. For example, let's say you've invented a new type of ergonomic keyboard designed to reduce strain on wrists and fingers. Your patent application would include a detailed description of the keyboard's design, materials, and functionality, supported by drawings showing its various components and how they interact. Your claims would then define the specific features of your keyboard design that you believe are novel and non-obvious, such as the unique arrangement of keys, the angle of the keyboard surface, or the specific materials used in its construction. Crafting a strong patent application is a complex task that requires technical expertise, legal precision, and a deep understanding of patent law. While it's always advisable to seek professional assistance from a registered patent attorney or agent, understanding the basic structure and elements of a patent application can help you effectively communicate your invention and collaborate with your legal team. Imagine spending months, even years, perfecting your invention, only to discover that someone else has already patented a very similar idea. This scenario, unfortunately, is not uncommon and highlights the critical importance of conducting thorough prior art research before filing a patent application. Prior art research involves systematically searching for any existing information that is relevant to your invention. This could include patents, databases of granted patents and published patent applications worldwide, such as the USPTO database, Google Patents, and eSpaceNet. It also includes technical literature like scientific journals, conference proceedings, technical reports, and other publications in your field of invention. And let's not forget product information, publicly available information about existing products, such as product catalogs, websites, and marketing materials. Conducting effective prior art research requires a combination of database searches using relevant keywords and manual review of potentially relevant documents. It's often a time-consuming and iterative process, but the effort is well worth it. For example, imagine you've invented a new type of foldable smartphone. A thorough prior art search might uncover existing patents for foldable devices, flexible display technologies, and hinge mechanisms. By carefully analyzing this prior art, you can identify potential roadblocks to patentability, refine your invention to differentiate it from existing technologies, and strengthen your patent application by addressing potential novelty and non-obviousness concerns. Failing to conduct thorough prior art research can have serious consequences. It could lead to filing a patent application for an invention that is not actually patentable, wasting time, money, and effort. In some cases, it could even expose you to accusations of patent infringement if your invention is found to be too similar to an existing patented technology. While securing a patent for your invention is a significant achievement, it's equally important to ensure that you have the freedom to operate, meaning that your invention does not infringe on any existing patents held by others. Patent infringement occurs when you make, use, sell, or import a product or process that is covered by another party's patent without their permission. Freedom to operate, or FTO analysis, is a crucial step in the product development process, helping you identify potential patent roadblocks early on and make informed decisions about your invention's design, features, and market launch strategy. FTO analysis typically involves, first, identifying relevant patents by conducting a comprehensive search for patents that cover technologies similar to your invention. Second, analyzing patent claims by carefully reviewing the claims of identified patents to determine if your invention falls within their scope of protection. Third, assessing infringement risk by evaluating the likelihood of infringement based on the similarity between your invention and the claims of existing patents. For example, imagine you're developing a new type of wireless charging pad for smartphones. An FTO analysis might reveal that a competitor holds a patent on a specific coil arrangement used in wireless charging technology. If your charging pad utilizes a similar coil arrangement, you could be at risk of patent infringement. Understanding the FTO landscape can help you make informed decisions about your invention. You might choose to modify your design to avoid infringing on existing patents, seek a license from the patent holder, or even challenge the validity of the patent in court. Conducting an FTO analysis can be a complex and time-consuming process, requiring specialized knowledge of patent law and search techniques. It's often advisable to seek professional assistance from a qualified patent attorney or agent experienced in FTO analysis. Filing a patent application is just the first step in a journey that can often take several years and involve multiple rounds of back-and-forth communication with the USPTO. This process, known as patent prosecution, is where your application is examined, challenged, and ultimately, if successful, granted. Once you file your application, it is assigned to a patent examiner with expertise in the relevant technological field. The examiner reviews your application for completeness, clarity, and compliance with all applicable rules and regulations. They also conduct their own prior art search to assess the novelty and non-obviousness of your invention. The examiner will then issue an office action, a written communication outlining any objections or rejections they have regarding your application. These objections might relate to the clarity of your claims, the sufficiency of your disclosure, or the patentability of your invention in light of the prior art. You then have an opportunity to respond to the office action, addressing the examiner's concerns through arguments, amendments to your application, or a combination of both. This back-and-forth exchange can continue for several rounds until the examiner is satisfied that your application meets all the requirements for patentability. So let's imagine you've invented a new type of energy-efficient window coating. The examiner might initially reject your application, citing prior art that discloses similar coatings. You would then need to carefully analyze the cited prior art, identify key differences between your invention and the existing technologies, and present arguments to the examiner demonstrating the novelty and non-obviousness of your invention. This might involve amending your claims to more narrowly define the scope of your invention, or providing additional evidence, such as test data or expert opinions, to support your arguments. If your arguments are persuasive and the examiner overcomes all objections, your application will be allowed and eventually mature into an issued patent. However, if you are unable to overcome the examiner's objections, your application will be abandoned. Receiving a notice of allowance from the USPTO indicating that your patent application has been approved is a momentous occasion, but honestly, it's not the end of the journey. Several crucial steps remain before your patent is officially granted and you can fully enjoy the fruits of your inventive labor. First, you'll need to pay an issue fee to the USPTO. This fee covers the costs of printing, publishing, and issuing your patent. Failure to pay the issue fee on time can result in the abandonment of your application, so it's essential to meet this deadline. Once the issue fee is paid, your patent will be assigned a patent number and officially issued on a designated date. This date marks the beginning of your patent term, the limited period during which you have exclusive rights to your invention. In the United States, the patent term for utility patents is generally 20 years from the date the non-provisional application was filed. However, your patent journey doesn't end there. Throughout the life of your patent, you'll need to manage various fees and deadlines to maintain its enforceability. These include maintenance fees, which are due at specific intervals, typically at 3.5, 7.5, and 11.5 years after the patent is granted, to keep your patent in force. Additionally, you may choose to file continuation applications, which allow you to pursue additional claims or make modifications to your invention after the original patent has been granted. This can be a strategic move to broaden your patent protection or adapt to changes in technology or market demands. Navigating the patent process involves not only understanding the legal complexities, but also managing the associated costs. Patent fees can vary significantly depending on the type of patent application, the complexity of the invention, and the length of the prosecution process. Here are some of the key patent fees to be aware of. Filing fees are paid when you initially submit your patent application, and these can vary based on the type of application and the size of your entity, whether that's a small entity, micro entity, or a large entity. Search fees are paid to the United States Patent and Trademark Office to conduct a search for prior art relevant to your invention. Examination fees cover the cost of having your application reviewed by a patent examiner. Issue fees are paid upon the allowance of your application to cover the costs of printing and issuing your patent. Maintenance fees are due at specific intervals throughout the life of your patent to keep it in force. It's important to note that failing to pay patent fees on time can have serious consequences. Missed deadlines can result in the abandonment of your application or the lapse of your patent, potentially costing you valuable patent protection. To avoid missing crucial deadlines, consider setting reminders, calendar important patent deadlines, and set up reminders to ensure timely payment. Utilizing United States Patent and Trademark Office resources is also a good idea. The USPTO website provides a wealth of information on patent fees, deadlines, and payment options. And of course, seeking professional assistance from patent attorneys and agents can help you manage patent deadlines and make sure all fees are paid correctly and on time. Securing a patent is a significant accomplishment, but it's really just the first step in leveraging your invention for commercial success. Once you have a patent in hand, you have several options for monetizing your invention and enforcing your exclusive rights. For monetization, product sales are a straightforward approach. If your invention is a physical product, you can manufacture and sell it yourself, or license the rights to another company to produce and distribute it on your behalf. Licensing is another strategy where you grant another party the right to use your invention in their own products or services in exchange for royalties or other forms of compensation. You can also consider the sale of the patent, selling your patent outright to another entity, and transferring all ownership rights and future revenue streams. Joint ventures are another option, collaborating with another company to develop, manufacture, or market your invention, and sharing both the risks and rewards. When it comes to enforcement of patent rights, if someone infringes on your patent, you have the right to take legal action to stop the infringing activity and seek compensation for damages. This typically involves sending a cease and desist letter to the infringer, and if necessary, following up by filing a patent infringement lawsuit in federal court. For example, imagine you hold a patent on a novel design for a bicycle helmet. You discover that a competitor is selling helmets that incorporate your patented design without your permission. You would first send a cease and desist letter demanding that they stop selling the infringing helmets. If they refuse to comply, you could then file a patent infringement lawsuit to protect your patent rights. If you're seeking patent protection in multiple countries, you'll need to file patent applications in each desired country or region. The Patent Cooperation Treaty, or PCT, provides a streamlined process for filing international patent applications, allowing you to initially file a single application that can later be extended to specific countries. The world of patents is constantly evolving, driven by rapid technological advancements, changing market dynamics, and emerging industries. Staying ahead of these trends is, honestly, crucial for inventors and entrepreneurs looking to protect their innovations and capitalize on new opportunities. Here are a few emerging trends shaping the future of patents. Artificial intelligence, or AI, is a big one. As AI technologies rapidly advance, we're seeing a surge in patent filings related to machine learning algorithms, computer vision systems, natural language processing, and other AI-driven innovations. Biotechnology and pharmaceuticals are also at the forefront. The life sciences industry continues to be a hotbed of innovation, with groundbreaking discoveries in gene editing, personalized medicine, and novel drug therapies driving a steady stream of patent applications. Green technologies are gaining momentum too. With growing concerns about climate change and environmental sustainability, there's increasing demand for clean energy solutions, sustainable manufacturing processes, and other green technologies. This trend is reflected in a surge in patent filings for solar panels, wind turbines, electric vehicles, and other eco-friendly innovations. Software and mobile applications have also become increasingly common subjects of patents, covering everything from innovative algorithms and data processing techniques to user interface designs and mobile app functionalities. Staying informed about these emerging trends can help you identify promising areas of innovation, assess the patentability of your own inventions, and make strategic decisions about your patent portfolio. The path from a spark of an idea to a patented invention is rarely linear or easy. It's a journey filled with challenges, setbacks, and moments of both frustration and exhilaration. But for those who embrace the challenge, who dare to dream big and persevere through adversity, the rewards can be immeasurable. A patent is more than just a legal document. It's a testament to your creativity, your ingenuity, and your unwavering belief in the power of your ideas. It's a shield that protects your invention, a tool that can unlock commercial success, and a legacy that can inspire future generations of innovators. As you embark on your own patent journey, remember that you don't have to navigate this complex landscape alone. Seek guidance from experienced patent professionals, connect with fellow inventors, and never stop learning and refining your understanding of the patent process. The world is waiting for your next great invention. Go forth, create, innovate, and protect your ingenuity. The future of innovation starts with you.